Hi, welcome to Module 32 of your Intellectual Property course. This module will look into compulsory licensing of patents as well as other uses of patents without authorization. As you would have seen in the first part of your course, patent regimes are configured so as to foster a delicate balance between private exclusionary rights on one hand, which are meant to incentivize innovation, and on the other hand, a public or social interest in accessing that innovation at affordable rates. Ensuring that this balance is achieved requires nuanced exceptions and limitations on the broad patent right that is generally granted to the right holder. Part of this configuration is the inclusion of use without authorization licensing mechanisms. This allows the diffusion or dissemination of the innovation even when the right holders refuse to voluntarily engage in such action. Examples of situations where this is done is when the patent holder's behavior is seen as abusing their patent rights, or when the countervailing interest is seen as significant enough to justify an interruption of the right holder's patent duration. As seen in slide number 2, an example of this is when, say, an MNC pharma company has a patent over a drug but doesn't sell the drug in India. This often happens because they want to protect their right in India, but they haven't gotten around to marketing that drug in India or developing the drug for India, or they might not see India as a market which is valuable enough to invest into marketing that drug in India. However, this also prevents generic companies in engaging in such behavior. If, in case the MNC pharma company does not license that patent to generic companies, this could be seen as an abuse of their patent right. So one major method of achieving this balance is the inclusion of these quote-unquote use without authorization licensing mechanisms. It's relevant to note the history of how this came about. After the first substantive harmonization which occurred with the adoption of the WTO TRIPS agreement, countries were required to ratify the TRIPS agreement if they wanted access to the global trading regime. This, of course, ensured that membership was very widespread, with nearly all countries wanting to access the global trading regimes, and then this led to substantive norms being harmonized across all member countries. In the background, however, decisions on what went into the draft on the TRIPS agreement were very controversial. Developed countries demanded much more stringent norms for intellectual property, while negotiators from developing countries, especially India and Brazil, did not have such norms in their countries earlier and did not want to give in to accepting such stringent norms for their countries, which were still poor and developing. So what they did was they demanded flexibilities to ensure that the populations in their countries were not priced out by the exercise of patent rights from incoming multinational corporations, especially in crucial sectors such as public health. In what was arguably one of the biggest wins for developing country negotiators were provisions allowing for certain uses of patented products without authorizations from the patent holders being introduced into the text of the TRIPS agreement. Of these various use without authorization licensing mechanisms, compulsory licensing is by far the most prominent. The field in public health in particular has been the most visible in this innovation access tension. The other types include government use, experimental use, and Bolar exemptions. You can see these forementioned on slide number 3. Let's first look at these mechanisms as they exist under the TRIPS agreement. As earlier chapters would have shown, patent law and policy can be structured so as to include broad exclusions in terms of patentable subject matter, robust patentability criteria, pre-grant and post-grant oppositions, all of which can contribute towards carving out a patent regime that ensures only genuine innovations are rewarded with patent rights. Nonetheless, there are situations where patents can inhibit access to important products, and permissions of rights holders cannot be permitted to block out the licensing of that product to generic manufacturers. It is for these circumstances that compulsory licenses and other unauthorized uses were introduced, and these are some of the most widely recognized TRIPS flexibilities against patent monopolies. Even prior to the substantive harmonization brought about by TRIPS, however, compulsory licensing has been steadily cementing its place in the legal regimes of countries across the world, including in India. Article 31 of the TRIPS agreement is a provision which allows for the government grant of a license to a third party to use a patent without the consent of the patent holder. It's interesting to note, though, that the phrase compulsory license doesn't actually find a place in the agreement. Instead, the broader phrase other use without authorization of the right holder is used. Thus, compulsory licensing is only part of the non-voluntary licensing agreements envisioned through this article. Government use is the other main type of unauthorized use covered by Article 31, and apart from these two, there are certain exceptions that function in the nature of unauthorized use, even though they technically find backing under Article 30, which is titled Exceptions to Rights Conferred. These are the research exemptions and Bolar provisions, as earlier mentioned. As described in slide number 4, compulsory licensing can be defined as the legally enforced mechanism through which patent holders are forced to license out their statutorily granted patent rights to third parties capable of fulfilling the reasonable requirements of the public by manufacturing the patented product at cheaper prices. Looking at Article 31, it does not define situations or cases in which a compulsory license can be granted, but rather sets out specific conditions for the grant. These are non-exhaustive, but they include prior negotiations with the rights holders. This means that the applicant must have attempted for a reasonable amount of time to have obtained a voluntary license on reasonable commercial terms. After having attempted this for some time and have failed with obtaining a voluntary license, then they can apply for a compulsory license. This is not required in cases of national emergency, other cases of extreme urgency, or public non-commercial use. It is also not required when a judicial or administrative body has granted the license for anti-competitive practices by the right holder. However, it is required that the patentee be notified as soon as reasonably practicable. The next condition is that if such non-voluntary license issues, then the patentee must receive adequate remuneration, taking into account the economic value of authorization. Further, in instances of non-authorized use that fall under this part, Article 44, subsection 2 limits the patentee's rights to remedies to this remuneration only. The next condition looks at the circumstances under which the compulsory license was granted. If these change and no longer validly justify the license and are unlikely to recur, then the license is to be revoked. Next, the scope of the grant must be limited to the purpose for which the license is conferred. Moving on, the licenses must be non-exclusive, non-assignable, and must be granted predominantly for the supply in the domestic market. However, if the license is granted due to anti-competitive practices by the right holder, this last condition is not necessary. Continuing on, the next condition says that there must be an independent reviewing authority to which the right holder can approach an appeal. And finally, where the license is for a dependent patent, that is, where authorization to a prior patent is required to work the latter patent, additional conditions include that the latter patent involves an important technical advantage of considerable economic significance as compared to the prior patent. Secondly, that the rights holders of the prior patent be entitled to cross-license on reasonable terms. And thirdly, that the use authorized for the first patent be assignable only with the assignment of the second patent. As can be seen, the agreement does not provide an exhaustive list of situations in which a non-voluntary license can be granted, nor does it limit the grounds for such licenses. Rather, it indicates possible grounds and sets conditions for the grant of a compulsory license. Therefore, the language in Article 31B, which mentions national emergencies, etc., as per when voluntary licenses negotiations are not required, does not limit the grant of compulsory licenses to those grounds alone. This was further clarified by the Doha Declaration, which specified that the member states have the freedom to determine the grounds upon which the compulsory licenses are granted. It also went on to state that member states have the right to determine what constitutes a national emergency or situation of extreme emergency, and that public health crises include those relating to HIV/AIDS, tuberculosis, malaria, and other epidemics can represent a national emergency or other circumstance of extreme urgency. As the compulsory licensing provision was largely seen as one that was meant to ensure countries could remedy public health emergencies and ensure access to medicines for the populace, several countries without local generic manufacturing capacity protested the provision which mentioned that licenses needed to be predominantly for the supply of the domestic market. This led to Para 6 of the Doha Declaration and the August 30th decision in 2003. You can see this in slide 7. As mentioned in slide 7 of the presentation, Para 6 of the Doha Declaration and the August 30th decision allowed countries with local manufacturing capacity to export drugs to countries with public health needs, thereby waiving the predominant supply to the domestic market requirement. While discussing non-voluntary licenses under Article 31, it is also useful to look at exceptions to rights conferred as described under Article 30, as the spirit of the provisions are very similar to each other, and the ambits may even sometimes overlap. Article 30 states that limited exceptions may be provided when they do not conflict with normal exploitation of the patent and do not unreasonably prejudice the legitimate interests of the patent holder, taking into account the legitimate interests of third parties. This has been recognized as a source of two types of exceptions: experimental use exceptions and Bolar exemptions. Experimental use exceptions under this provision enable experimental use with registered patents and allow implementing countries to encourage the understanding and absorption of underlying technologies. Similarly, the Bolar exemption provisions permit third parties to manufacture and use a patented product for the purposes of obtaining information necessary for marketing approval. This allows third parties to bring their products to the market as soon as a patent expires. A WTO panel, in the case Canada Patent Protection of Pharmaceuticals, has ruled on the Bolar exemptions in 2000, holding it as compatible with the TRIPS agreement. In both these exceptions, the normal exploitation of the patent is not interfered with, and interests of the rights holders as well as third parties are balanced appropriately.